Hello and welcome to the guest lecture of week 10 of the CIL eAcademy, and actually the last week of the CIL eAcademy. We are very proud that we made it so far, and we are also extremely happy to have with us today for a guest lecture for the week, Professor Jeffrey Chan, who will be speaking to you about international criminal law, a quick briefing. And I appreciate very much that Professor Jeffrey Chan and Professor Sergey Sayapan have sort of coordinated, and so in order to complement the guest lecture, and also with our lecture this week, and Professor Sayapan, who is with us today also, and it's very nice to see him too. So let me just briefly introduce Professor Jeffrey Chan, who I will in advance apologize for just making a brief introduction, because I think, Professor, you have one of those CVs that it's very hard to try to sum up quickly, but I'll try to highlight just some of your areas of experience. And I think you're probably one of and they our participants have met already some of the Singaporean leading international lawyers, and I think we can put you also in that category, because you've had a lifelong service in the Singapore legal service, holding numerous positions, including having been appointed chair of UNCITRAL of the United Nations, and you've been also Deputy Solicitor General, so a whole life of service in the Singapore legal service. But I wanted to highlight that you're currently adjunct professor of international humanitarian law at the law school at the National University of Singapore. And from what I was able to verify in the internet also, you were at one point vice chairman of the Singaporean Red Cross, which I think certainly also has brought you a lot of experience in this important area of international law, which is IHL and international criminal law. So on behalf of Dr. Nilofer Oral, who's not able to be with us today, and myself and all the participants in the Academy, let me end by giving you a warm welcome, Professor Jeffrey Chan, and also by thanking you for taking time to come and speak to our participants in the Academy. So after your initial presentation, we'll have our usual exchange with the participants, who I'm sure will have questions for you. So the floor is yours.
Thank you very much, Patricia, and good afternoon, everyone. I'm so happy to be able to be the last guest lecturer for this eAcademy, and I hope I will match up to the standards of the other lecturers, and of course of Dr. Serapin, which you have all enjoyed in the past few weeks. Now, there's one point which I think which I'd like to underscore in the respect of my experiences. I was vice chairman of Singapore Red Cross. I was the international vice chairman. So international humanitarian law and its development and impact on Singapore fell within my scope of responsibility. And in this capacity, I interacted very, very regularly with the ICRC. And I was actually present in many of the events which was mentioned by Dr. Serapin yesterday. For example, the discussions on the role of the ICRC in relation to international human rights law. And also, I was in Geneva during the time when the third protocol to the 1977 Geneva Conventions was adopted by the Assembly of the International Red Cross. That was the most exciting event. There's a whole history to it. But maybe I can clarify that the use of the red crystal, which was mentioned yesterday, a little bit more. Now, the reason why this will serve as an introduction to what I'm going to say. The reason why the Red Cross was chosen was because it was thought at that time that in the event of a person being wounded after battle but still alive, then he can use his own blood to draw a cross on his uniform to signify that he needs help, so that later, after the battle, when the help arrives and people are going through to see who they can help, they can identify the person who needs help. So that was the origin for the Red Cross. And by coincidence, it was also a reversal of the Swiss flag. The same applies to the Red Crescent. In other words, somebody can use his own blood to draw a crescent on his uniform, and that signifies to those coming to help that he needs help. Now, both of these are very distinctive, and they are very, very easy to draw, right? And they are protected emblems. Protected means that under international law, it is an offense for anyone to attack any person or vehicle displaying these emblems. And it's for this reason that these emblems are very, very jealously protected by not just the Red Cross, but all national societies of Red Cross and by governments, because they're so important, because it is an offense under international law to attack a protected emblem. And the protected emblems were the Red Cross, the Red Crescent, and for a short while, the Red Lion and Sun. Then there was a development. And that development was in relation to Israel, because Israel did not want to use the Red Cross or the Red Crescent. They wanted to use the Red Star of David, which is a symbol of their National Red Cross Society, known as the Bagan David Adom. But the Star of David is also the symbol you find on Israeli military installations and military equipment such as tanks and aircraft. So there'll be a confusion. There'll be a confusion if the Star of David is used as a protected emblem. So there was many years of discussion as to whether or not Israel should be allowed to use the Star of David. And the US took the position of the Israelis and advocated very strongly and also quite ferociously for Israel to be allowed to use the Red Star of David. Now, eventually, some bright minds in the ICRC and in the international community came with the idea of a red crystal, the red rhombus, which is 4 sides with blank in the center, which is also quite easy to draw, a little bit more difficult, but it's also very distinctive. So this was proposed as a means whereby whichever state does not wish to use a Red Cross or Red Crescent can use a red crystal, and they can put whatever symbol they wish within the red crystal, and that would be a protected emblem. So Israel, after the third protocol to the 1977 Geneva Conventions was passed, Israel then put the Star of David in the middle of the red crystal, and that became the Israeli symbol for their Bagan David Adom, or the equivalent of the National Red Cross Society. And there's a symbol you find on Israeli military medical equipment, as well as on Israeli military installations and military equipment. So that is a history for the use of red crystal. It's quite an interesting history, and I wish I had more time to tell you about all the twists and turns of this debate as it progressed through nearly a decade. But coming to my talk for today, I've been asked to speak about international criminal law, and I am most happy to talk about it. I do not teach international criminal law, but it's related to the subject which I teach, which is international humanitarian law, the same subject which you heard Professor Sergey speak extensively on. International criminal law is related, but it is quite different. And I hope to show you how different it is. Now, if I may share the slides which I have. Okay. So let me begin with some preliminary words. Okay. Okay. Firstly, international criminal law. International criminal law is actually a term that you never hear about 100 years ago. It was unheard of. It is a fairly new development. In fact, you don't even hear of this term until fairly recently, probably within the past 30 years or so. Before that, you hardly hear of international criminal law. What is international criminal law? It is a subset of public international law. Public international law, the original name was the law of war and peace. The law of war comes before the war of peace. It's also known as the war of nations. And it is a law that applies to regulate the relationship, the legal relationship between states and only states. Public international law does not concern natural persons, or entities which are not states. But it does concern also entities which comprise of states, such as international organizations like the United Nations. Now, international criminal law is very different because international criminal law deals with the criminal liabilities of natural persons, of human beings, not of states, in the area of public international law. Note what I said, public international law only deals with states, but international criminal law deals with the liabilities of natural persons, human beings, according on rules which are promulgated under public international law, in other words, which are promulgated by states. Now, the term international criminal law, being such a new term, has generated quite a fair bit of misunderstanding and also differences of views as to its scope. Different writers have taken different understandings of what is encompassed within the term international criminal law. Well, my favorite, or the understanding which I choose to adopt actually is, I believe, the core understanding, and that is international criminal law is the law applicable to investigate and punish natural persons, not entities, not states, but natural persons for crimes which are established under public international law, i.e. the law of nations. So this is a law that makes individual persons liable for crimes established by states. So the question, what are the crimes punishable under public international law? How are these crimes established? Now, first and foremost, crimes. What are international crimes? Firstly, all criminal laws are domestic. All criminal laws are domestic. They're all domestic, enacted by domestic legislature, or they're created by courts, and they're enforced in domestic courts. Criminal laws of a state are not enforced in the courts of another country or in an international courts. Domestic courts do not have jurisdiction over matters committed outside their jurisdiction, because all criminal laws are territorial. Courts do not have, generally, extraterritorial jurisdiction except under very specific circumstances. Why? Because for a court, which is the embodiment of the sovereign of a country, to exercise jurisdiction over matters in another state's territory is an affront to the sovereignty of that other state. That can start a war. So courts do not exercise their jurisdiction in the territory of another state. But there was one, and still is one major exception, and that exception is piracy. Piracy traditionally and historically is the only crime where courts, domestic courts of a state, can exercise jurisdiction over matters which are occurring or have occurred outside the territory of their state. Now, why is that so? That's because piracy is considered as a crime jure gentium, in other words, a crime against humanity. It's not a crime against a particular law of a state or a crime against a state, but a crime against humanity as a whole. That was the theory. But there's also a practical reason, because piracy is committed in the high seas. It's outside the territory of any court. It's outside the territory of any country. So if it's not punished by any country, then there's no means whereby piracy can be suppressed and the safety of the high seas ensured. So piracy was created as an exception to the rule that courts will not exercise jurisdiction outside the territorial boundaries of their own state. So seen in this way, piracy was and is the first and historically the only international crime, the only example of the exercise of international criminal law. That was the position historically. Now, of course, there were developments, and the development actually occurred in the area of warfare, in the area of armed conflict, And this is where there is a link with international humanitarian law or the law of armed conflict. The first recorded instance of an international war crimes trial where a court or tribunal exercised jurisdiction in order to punish for an international crime was said to be the trial of Peter of Hagenbeck, which took place in 1474 in what is now Germany. Now, Peter of Hagenbeck was the governor of the province of Alsace, which at that time formed part of the lands of Duke of Burgundy. Now, the Duke of Burgundy was at loggerheads with the Holy Roman Empire, and there was a war. Now, Peter was captured and was put on trial by the Holy Roman Empire, who convened a tribunal of 28 judges from various cities all over Northern Europe, basically Northern and Northeastern and Central Europe, rather. Now, this trial was very interesting because it was the first recorded trial whereby a commander was found guilty, not for what he did, but for what his subordinate did, because this trial established the principle of command responsibility, which is one of the elements of international humanitarian law. So under this particular doctrine, a commander is liable for crimes committed by a subordinate, even if he had not ordered them to commit the crime or intended they be committed. He is still to be liable for those crimes, and the penalty can be death, as what happened to Peter of Hagenbeck. Now, Peter also raised the defense of obedience of superior orders. He said, well, whatever happened was actually not because I wanted it to happen, but because I was obeying the orders of the Duke of Burgundy, my boss, my overlord. So go after him, don't go after me. Well, that was denied. Says, whatever it is, you might be obeying orders, but obeying orders does not excuse the crimes that you committed. So Peter of Hagenbeck was found guilty by this tribunal and was executed. Note, Peter was tried by the victorious side in the conflict, not by his own side. He was tried by the winner of that particular war, right? But even though this took place 600 years ago, the trial of Peter of Hagenbeck influenced development, which eventually led to what we now know as international criminal law. Why is this so? Well, let's take a look back into history. Well, firstly, some of the basics. Peter of Hagenbeck's trial took place before the 30 Years' War in Europe. This was a war ostensibly between Protestants and Catholics, but well, the leaders of the various sides were changing sides as and when it suited them, so it can hardly be said to be a religious war. It was a very long and brutal war between basically the Germanic-speaking states of Europe and also Northern European states such as Sweden and Denmark. They were also involved in the 30 Years' War. It was a very long war. And towards the end, the northern part of Europe was completely devastated. And the parties were exhausted, and they decided to sit down and work out a treaty to end the war. That treaty was the Treaty of Westphalia. And central to that treaty was an agreement that no state will intervene in the affairs of another state. Because the 30 Years' War started because one state said that it did not like what the other state was doing. And since it did not like, and as Professor Sergey mentioned yesterday, war was an accepted means of international relations in those days, it went to war. So because of this, the 30 Years' War started and devastated much of Europe. So the agreement to the end was that every state, in fact, they use the word prince, every prince will be sovereign in his own land. No other prince could intervene in what he wants to say. And that is the root of the present basic premise of all international relations, i.e. state sovereignty. In other words, one state will not intervene in the domestic matters of another state. is fundamental to international relations today. There was an exception developed in the 19th century by Western European states who argued or developed the doctrine that if a state compromises or contravenes the human rights of its own people, then other states have a right to intervene in order to put the situation right and protect the human rights of the people of that other state. Now, this was used by the Western European states in order to intervene in the domestic matters of the Ottoman Empire. Of course, the political aim was to weaken the Ottoman Empire, and they succeeded. In the end, as I think many of you know, the Ottoman Empire faded after the First World War, and before that, Turkey was known for many years as the sick man of Europe, partly because of all these interventions by other European powers, ostensibly on the basis of protecting the human rights of the people of the Ottoman Empire. But there was a small exception. It wasn't that popular, and it was obviously very political. It was as political then as it is now. So while all this was happening, there was very little mention about international criminal law, about the right of persons to be tried by an international tribunal for crimes committed against international law. There's no mention at all. International criminal law went to sleep for hundreds of years after Peter of Hagenbeck. But war crimes and other atrocities were tried and they were punished, but under domestic laws, not under international law, and by domestic tribunals, not in courts, not by international tribunals and courts. Now, after the First World War, Germany lost the First World War, the victorious Allied powers sought to punish the leaders of Germany by bringing them to trial before an international or a number of international tribunals. But the premise of state sovereignty, Westphalian sovereignty, was so strong that they felt they could not do it unless Germany consented to it. Germany, of course, refused to consent, but said that they would try the war criminals of the First World War on their own domestic law. And they did. This was known as a Leipzig Tribunal. 12 German leaders, not the Kaiser, because the Kaiser fled to the Netherlands, but 12 German government leaders were tried as war criminals, but by German domestic court in Leipzig. This was known as the Leipzig trials. All were either acquitted or given very light punishments, very light. And the Allied powers, till today, if you read the writings on the Leipzig tribunals, the Leipzig tribunals has been termed as a failure of international criminal law as well as international humanitarian law. Now, what then is international humanitarian law? Here I'm at risk of repeating much of what Professor Sergeyev has spoken to you, but in order to provide the backdrop to what I'm about to say, I think I must make a few remarks about international humanitarian law, or IHL. As you all would know by now, IHL is also known as the law of war, or more popularly as the law of armed conflict, and it originated as customary international law. It is a species of law which was developed not by lawyers, thank goodness for that. It was developed by soldiers. It was developed by military men who developed codes among themselves as how they would like to treat each other if they were in the other's shoes. And I must acknowledge to a very large extent, many of the principles of modern day international humanitarian law have been influenced by European notions of chivalry during the Middle Ages. Chivalry, and yesterday there was a discussion on honor. Chivalry and honor goes hand in hand. So, for example, not attacking an enemy when he has already laid down his arms, is no longer a combatant. That is chivalry, that's also honor, and this is also one of the principles of international humanitarian law. So all these were developed largely by military men. They're not developed as custom by lawyers. However, Professor Sergi has also mentioned about the development of treaty law and in the IHL, and also of the role of the International Committee of the Red Cross. Now that happened after the Battle of Solferino, where John Henry Dunant, the founder of the Red Cross, observed the battle and was so struck by the suffering after the battle, they proposed the establishment of an international organization in order to provide for the wounded and sick after military conflicts. And that led to the formation of the Red Cross. And in order to give the Red Cross standing, the first Geneva Convention, also known as the Red Cross Convention, was signed by initially very few states, and they're all European states. But then directly to the second Geneva Convention, the third Geneva Convention, and eventually to the 1949 four Geneva Conventions, Conventions 1 to Convention 4. So now, international humanitarian law is largely treaty law, because many of the customary practices and doctrines have been codified in the Geneva Conventions and the other treaties, which all deal with protection of victims of armed conflicts. And victims include military men, combatants who have no longer, who are no longer combatants. Now, IHL basically established what are the lawful means and methods of warfare, and breach of these rules are punishable as crimes. There are two types of breaches. There are breaches and there are grave breaches. If they're grave breaches, and the treaties define what are grave breaches, then states can exercise extraterritorial jurisdiction. In other words, universal jurisdiction. You can punish in your territory for a crime that's committed in another territory. So it's extraterritorial, it's universal. And that's because the laws, the rules apply universally. The rules of IHL apply to everyone, everywhere. Right? So how then is IHL enforced? IHL treaties, which now embody the laws of war, are required to be enacted into domestic law. They do not stand by themselves. They have effect only when they are enacted into domestic laws by the states or parties to the Geneva Conventions and the other IHL treaties. Thus, once they're enacted, the breaches of these rules are punishable under domestic law, not international law. They are punishable under domestic law or under the military courts of the state where the offender is a member of. They are not enforced by international tribunals. That was the basic structure for the enforcement of IHL. Now, how is IHL related to international criminal law? Well, you can see that there is a relationship in the sense that it provides for the establishment and punishment of international crimes. The crimes are established by treaties, which are internationally negotiated and agreed upon, but the enforcement is under domestic law. The treaties, the rules are enacted as rules of domestic law, and the proceedings are domestic proceedings, not international proceedings. And if there are grave breaches of the convention, in other words, the rules have been contravened in a very egregious manner, then states are empowered to exercise universal jurisdiction, and other states are required to assist in the enforcement of these rules. So all this took place during the several hundred years when international criminal law was unheard of. So while international criminal law was dormant since the time of Peter of Hagenbach, IHL was zooming away. It was developing very steadily in the years from the time of the establishment of the first Red Cross Convention, the first Geneva Convention, right up to the Second World War. Now we come to the Second World War and the developments after that. The Second World War was a shocking experience for the world as a whole, because enormous atrocities were committed by Nazi Germans and by the Japanese. And the exposure of these atrocities shocked the whole world. In fact, there were already rumors that very bad things were happening. But when the investigations were conducted and the truth came to be known, the rumors paled in comparison to the actual gravity of what was committed by Nazi Germany and by Japan. And that led to calls, worldwide calls, that those responsible for the war must be punished. they must be punished. In the past, this was not always the case. Not always the case. After a war, normally the elites of the countries at war will get together, have a dinner and shake hands and go back to do whatever they were doing. But this was one war where people felt that so much bad things, so much evil things were done that there had to be punishment. So the victorious Allied powers established various tribunals in order to investigate and bring to trial the persons responsible for the war itself, as well as for the many atrocities committed during the war. The most notable tribunal would be the Nuremberg Tribunal. I think some of you would have already heard of it. Then there's also the Tokyo Tribunal, which was the tribunal to try the Japanese war criminals, and there were tribunals which were established in various places, like, for example, in Singapore, where I am, to try Japanese officials for atrocities committed here. And we can say, if we need to identify a point in time when international criminal law commenced, it was from this point in time. This was the time when international criminal law began a life of its own. Why? Because all the defendants were tried. All the war criminals were charged with crimes which were international. They are international crimes. They are not crimes under domestic law. They're crimes under international law. And the defendants were tried and punished by tribunals which were established not by domestic law, but pursuant to international agreements, albeit that agreements to establish its tribunals were only among the victorious Allied powers. And here the victorious Allied powers are the United States, the European powers, notably Britain, France, and the Netherlands, and China. They were the victorious Allied powers. Right. Now, there are some troubling issues that these tribunals were faced with, very troubling issues, legally very questionable. The major issue is that most of the conduct for which the defendants were charged were not crimes at the time when they committed or carried out their conduct. For example, the crime of conspiracy to conduct aggressive war, unheard of before. Crimes against humanity. Well, prior to this, crimes against humanity only meant piracy, nothing else. And yet, it was felt we had to use this term because the conduct, particularly the Holocaust, was such that it is a crime against humanity as a species, not just a crime against a person. It was a crime against the entire human species. But these were not crimes which existed at the time they were carried out. And there was no law that prohibited such conduct at the time they were carried out. As you're all well aware, all legal systems prohibit retrospective criminal legislation, all legal systems, because the person should not be punished in a criminal court for acts or omissions which are not crimes at the time when they were carried out. Now, a particular problem arose in respect of military personnel, the generals and the commanders, because having surrendered, they were prisoners of war. Now, being a prisoner of war is often misunderstood. It's actually a privileged status. It is a protection, because if you're a prisoner of war, you cannot be charged for crimes under domestic law. You can only be charged and punished for crimes which are breaches of the laws of war, i.e. the Geneva Conventions and the related treaties. You cannot be charged for domestic court. In the domestic court for crimes such as murder or rape or pillaging, although these are, unless these are also crimes under the Geneva Conventions. And you cannot be tried before a domestic tribunal. You can only be tried before an international tribunal, a tribunal there's a convened specifically in order to try for crimes. It can be a domestic tribunal, but they are convened in order to try for crimes committed against the Geneva Convention, not against domestic law. But all these legal issues were glossed over by these tribunals, which were established after the Second World War. And interestingly, the Nuremberg Tribunal cited the Peter Hagenbach case as a precedent for exercising its jurisdiction over crimes which did not exist at the time they were committed, just as Peter was charged for crime which did not exist at the time when he committed those crimes. And it was said that the charge of crime against humanity is not a retrospective application of criminal law, because it's always been an offense for anyone to commit a crime against humanity. Now, interestingly, a lot of how the Nuremberg Tribunal relied on Peter of Hagenbeck in order to justify the jurisdiction can be seen from the writings of Professor Leslie Green. I learned international law from Professor Leslie Green, and he was a former dean of the University of Singapore Faculty of Law, although after he left Singapore, he was for many years in the University of Alberta in Canada. Now, all this took place after the Second World War, but there are lingering questions still today that all these tribunals established by the Allied powers and which tried and convicted and even executed many, many defendants were actually questionable, because they smacked of victor's justice, right? And this was identified in a very famous dissenting judgment of Justice Rahabinot Pal of India in his judgment at the Tokyo Tribunal. This is a judgment which is very challenging to read. It is 1,000 pages long. And I confess, I've not read the whole judgment. I've only read extracts of the judgment, but it is a superb judgment. And one of the points which Justice Paul mentioned was that the tribunals lack common sense. They lack credibility because similar conduct by Allied military men were not brought to justice. Only bad conduct by the losing side was brought to justice, which was exactly the case in the Peter of Hagenbeck trial. Okay. Now, after the Nuremberg Tribunal, again, international criminal law went to sleep. Hardly anybody talked about it. It was dormant. But there were massive developments in international humanitarian law. Here, the United Nations played a leading role. After the Second World War, the United Nations was established. The main aim of the United Nations was to prevent another world war, and international humanitarian law was seen as one of the vehicles in order to ensure that there will not be another war. So numerous conventions in the nature of international humanitarian law were established by the United Nations. And my slide set out some of these conventions. Then came 1991, where we had the Yugoslav wars between the component states of the Federal Republic of Yugoslavia, which broke up after the death of President Tito. But before this took place, there was a more significant event that took place, and that was the breakup of the Soviet Union. Up to that point in time, from Second World War, the world was caught up in the rivalry between the United States and the Soviet Union, with many countries taking sides, and a huge bloc of countries known as the non-aligned nations not taking any sides deliberately. But before, in the 1990s, coming to the 1990s, the Soviet Union imploded, and it was no longer a bipolar world. There was only one superpower in the world, and that was the United States. It was a unipolar world. In other words, the United States and its allies was able to basically direct international matters in the direction that would serve their interests. So in 1991, we had the Yugoslav wars. And in 1994, we had the Rwanda genocide, whereby as part of internal issues in Rwanda, one part of Rwanda, known as the Hutus, went after the other part of Rwanda, known as the Tutsis. They're actually the same people, but they were sociologically divided by the former colonialist Belgium, such that there's a sort of policy of divide and rule to make sure that the Belgians will continue to rule Rwanda. Well, the massacre led to about 500,000 people being killed. So this was reported massively by the Western media, but from the Western perspective. There's hardly any reports coming from other sides. Why? Because we are now in a unipolar world where the West was able to basically direct international matters in a way it preferred, and also direct international issues in directions that it would prefer. Now, the massive reporting by Western media led to pressures, especially by Western NGOs and by the liberal Western governments, notably the Western European governments and the United States, for those responsible for the atrocities committed during the Yugoslav wars and the Rwanda massacre, the Rwanda genocide, to be brought to trial and punished. And the United Nations was pressurized to act. And United Nations reacted by establishing the International Criminal Tribunal for the former Yugoslavia, or the ICTY, as well as the International Criminal Tribunal for Rwanda, the ICTR. Now, these are organizations established by the UN, but the statutes and rules were drafted by committees of experts convened by the UN. They're not drafted by legislature as such. They're drafted by groups of people who are supposed to have expertise in this field. But both these were ad hoc tribunals funded by the UN through the UN budget. They are not courts the way we understand courts to be. And their purpose was to bring to trial persons responsible for the authorities during the Yugoslav wars and Rwanda. What were they supposed to bring to trial for? Well, these persons were supposed to be arrested and tried for genocide, great breaches of the Geneva Conventions, in other words, war crimes, and for crimes against humanity. At that time, this was a very general understanding. There's no specific understanding of what these crimes meant. Now, all these defendants are officials or military commanders of the various fractions involved in these wars, and they're all over the place. But wherever they are, countries are supposed to extradite them to the courts of these two, of the courts of the ICTY and the ICTR, for them to be tried. And in the case of the ICTY, that we tried, brought to The Hague, and the case of the ICTR, that we extradited and brought to Arusha in Tanzania. Now, what then was the record of these tribunals? Well, firstly, the cost was very high. We're talking about hundreds of millions of US dollars. And the caseload was relatively light. In fact, they're supposed to try the most senior, the most egregious perpetrators. Most of these were tried by domestic courts, not by the tribunals. Then when you look at the record, many of the cases were not completed. And there were very high level of acquittals. My favorite example of the ICTY, where a huge amount of resources were applied, which came to almost nothing, was the trial of Slobodan Milosevic, the president of Serbia. He died before the trial, but before he died, in the preliminary proceedings, there were a huge number of proceedings at very great cost until eventually he died, and the case was abated. Now, also another feature of these tribunals was that a large number of NGOs, numbering the hundreds, suddenly were established, suddenly popped up, and they all claimed to assist the tribunals and the victims of the atrocities in obtaining justice. Hundreds of NGOs came up and they popped up. Now, the tribunals were slow and very ponderous, and people were watching. And there were complaints. There were complaints and suggestions that the tribunals were slow, and even that they were self-perpetuating. In other words, they are making sure that they continue. They're making sure that they continue. Because if the tribunal cease, then a lot of people will have to find other work opportunities. So in 2010, after a lot of debate, the United Nations voted to shut down both tribunals. And they set up a residual mechanism for international tribunals whereby all uncompleted cases are supposed to be transferred to this RMIT. Unfortunately, in my research, I've not been able to find much about how effective this IRMIT, the International Residual Mechanism for International Tribunals, have been. I've not been able to find cases which they've actually tried. There may be, but perhaps my research was not comprehensive enough. Now then, on this time came the International Criminal Court. Because the enthusiasm, there's a lot of enthusiasm for these tribunals to be established to punish and try persons responsible for atrocities, generated support for an old idea of an international court, a court, in other words, a permanent tribunal to try and punish people for breaches of international humanitarian law, genocides, war crimes, and crimes against humanity. This is an idea which has been there for more than 100 years, but it's taken a dominant seat all this while. But the establishment of the ICTY and ICTR gave added impetus to this idea. And there were a lot of calls, a lot of support for the establishment of an international criminal court in order to try for persons for genocide, war crimes, crimes against humanity, and the crime of aggression. Aggression in the old days was called waging aggressive war. In other words, you start a war when there's no reason to do so. So that is regarded as an international crime. And it was said that these are the crimes which are of most concern to the international community. That's why you need a special court to try them. So starting from 1994, the United Nations convened a series of conferences of member states of the United Nations to draft a statute for the International Criminal Court, or the ICC. And in 1998, the Rome conference, the final conference, was held in Rome. The conference lasted, I believe, 3 months. And it ended up by adopting the Rome Statute of the International Criminal Court, often colloquially referred to as the Rome Statute, just as the Rome Statute. Now, what then is the ICC? First and foremost, and I cannot emphasize this more, the ICC is a standing international court. In other words, it's permanent. It's not ad hoc. Then it is a separate organization from the UN. It is not part of the UN. It's not funded by the UN. It is a separate organization, but it is related to the UN in many of its processes. How is it funded? It's funded by contributions from the parties to the Rome Statute. So any state wishing to sign the Rome Statute must be aware that there will be a levy on it to fund the International Criminal Court. And what about jurisdiction? When does a court have jurisdiction? There are 3 main instances where the court can exercise jurisdiction. Firstly, when the crimes were committed by a national of a state party. So I'm a Singaporean. If I commit a crime, which is one of the crimes within the jurisdiction of the court, I can be extradited to the ICC for trial. Secondly, when the crimes were committed in the territory of a party to the Rome Statute, or a state that's not a party but has accepted the jurisdiction of the ICC. So there's a second limb of exercise of jurisdiction of the ICC. The final limb is when the crime was referred to the ICC prosecutor by the Security Council of the UN, but that will require a resolution of the United Nations. And of course, in the Security Council, you need full agreement of the major powers, the big 5, because they have the power of the veto. So this is something which is not easy to achieve in a crime which arose out of a sensitive international situation. Now, apart from the statute also contains what known as the elements of crime. And these are descriptions of what the crimes mean. And these are meant to assist the court in clarifying what are the offenses which are within its jurisdiction. These are quite detailed, and I must say, having read them, they're not easy to read. It is a penal code. It is a kind of penal code. Central to the ICC is the doctrine of complementarity. What does it mean? The doctrine of complementarity means that when a crime is committed, the primary jurisdiction is with the state where the offense occurs, the state where the crime took place. That state has got the primary jurisdiction. The ICC can try for that offense only when the state is unable or unwilling to exercise its jurisdiction over that offense. If the state is able to exercise or is willing to exercise, then the ICC cannot exercise jurisdiction. And of course, the third limb is when the Security Council refers the matter to it wherever that offense occurs. So this is the basis of the principle of complementarity. Now, under the Rome Statute, all state parties are obliged to assist the ICC. In other words, they are obliged to, if the person is not in the territory, then if it's in the territory, they must arrest and extradite the defendant to The Hague for trial by the ICC. That is what is meant by assisting the ICC. Now, the ICC processes are very complex. In fact, most of the ICC's time is taken up with procedural matters. Most of the hearings are procedural hearings. They're extremely complex, which means that they're extremely costly. And this is the same as with the ICTR and the ICTY. They're all very costly. And obviously, one reason why you have all these complex processes is to protect and preserve the human rights of the defendants. But what they've done is actually slow down considerably the pace of the proceedings. In other words, makes the proceedings less efficient, which means that less persons can be processed through these proceedings. And of course, it contributes to extremely, extremely high costs. ICC, the cost is I think by now over €1 billion. Now, what is the experience of ICC? Firstly, very high cost. Up to date, I think so. The last figure I saw was about €1.2 billion or something like that. Huge. Then there are relatively few cases. Now, one of the criticisms of the ICC is that it's been very selective because it seems that most of the cases come from Africa. They arose out of conflicts in Africa. ICC doesn't seem to have an eye on other conflicts, even though if you read the press every day, you find that the conflicts are happening all over the world. But the ICC appears to be focused on Africa. But now, its focus has changed. Its focus has changed to Ukraine. So there is a permanent ICC team right now, in fact, a number of ICC teams investigating only Russian atrocities committed in Ukraine. In fact, I believe the ICC prosecutor is right now in Ukraine. Now, ICC, like the ICTR and ICTY, also has a huge number of NGOs saying that they are supporting it in its work. Huge number. We're talking about thousands. We're not talking about hundreds. We're talking about thousands, mostly from the West. So their meetings, the annual conferences which are hold, tend to be very, very, very large affairs with thousands of NGO members attending them. I'm sorry. Now, because of the high cost of ICC, there was a proposal by some of the states, major states, to reform the finances of the ICC. In other words, to cut its budget. But the NGOs raised huge protests, and that proposal was dropped. One of the big deficiencies of the ICC is that some of the most important military powers in the world are not members of the ICC, notably the United States, China, Russia, India, Israel. These are major military powers. If they're not international, they are regional military powers, but they're not members of the ICC. And most importantly of all today, the US has become openly hostile to the ICC. This was because the ICC accepted a complaint against the conduct of some US soldiers in Afghanistan. America felt that that is not something the ICC should have accepted, and therefore America has become openly hostile to the ICC. Since the time the ICC was established, America has been pressing other states to enter into what are known as bilateral immunity agreements, whereby states agree not to extradite Americans to the ICC under any circumstances. So this was done largely in secret, but I understand that quite a few states have entered into these bilateral immunity agreements. And because there's open hostility to the ICC, America has imposed sanctions on ICC judges as well as members of the family. So it's not easy to be an ICC judge now. Because as you know, American sanctions include financial sanctions, which means you cannot use your credit card. You cannot use Visa, American Express, or MasterCard, because all these, the transactions are channeled through the US. So you cannot use all these credit cards. It can be a real pain to be someone sanctioned by the US. And ICC judges are sanctioned at present by the US. At the same time, given the record of the ICC so far, from 1998 onwards, many states have expressed doubts about what the ICC is doing. And I would like to mention two states in my region, Malaysia and Philippines. Both have doubts about the credibility of the ICC. What about Singapore, my own state? Well, the official position of Singapore is that Singapore is adopting a wait-and-see attitude to see how the ICC performs. And we're open to membership if the ICC, in fact, serves its objectives. In other words, it is not politicized. That's something which we need to be very carefully observant of. Right? So that brings me to the conclusion of my talk on international criminal law. What are the thoughts which I'd like to leave you with when we in these final moments of my talk? Firstly, I think international criminal law is a recent development. It is still developing. It still has a long way to go. Now, international criminal law, as it stands today, has been influenced very largely by the fact that it was developed in modern times in the context of a unipolar and Western-directed world, which means that not everybody is engaged with the principles that underlay its development, in particular, the establishment of the International Criminal Court. Much has got to be observed of the way international criminal law is developed, particularly to see whether or not it will be as politicized going forward as it has been in the past. Now, international criminal law is law. Law is meant to apply to all. It's meant to apply without fear or favor, and it's meant to apply fearlessly. If, as historical examples seem to suggest, international criminal law becomes politicized, there's just another vehicle for states to play with when advancing their geostrategic interests internationally. In such a case, then there'll be little credibility for international criminal law. And if international criminal law loses credibility, then I suggest that public international law, the law that governs the relationship between states, will also be adversely affected in the eyes of the people of the world. Thank you very much. So now I come to the question and answer session. I'll be prepared to answer any question that I think I'm competent to answer. And for questions which I'm not competent to answer, I'm happy to have the question put to me by way of email, and I'll reply with a written reply.
Thank you so much, Professor Chan, for this very clear and comprehensive briefing of international criminal law, bringing us to the difficult questions that I agree with you the world is facing today with regard to how international criminal law and the international criminal courts are working, and the challenges that are being faced. So I know we are right at our time limit, but because this is the last guest lecture, feel free to ask one or two questions to Professor Chan. I'll open the floor if you want to put your question in the chat or raise your hand and ask the question live. Okay, we have a question from Jung Woo. Please go ahead from South Korea.
Thank you, Professor, for very interesting and critical take on international criminal law from a non-Western perspective. I really appreciate that. The question I have is, I've noticed in IHL, which I'm a bit more familiar with than international criminal law, that a lot of the lawmaking and interpretation is largely being done by civil society, and that states seem to have taken a backseat to that. I'm just curious, is it a similar situation in international criminal law? And if so, what do you feel if this is problematic, or does this affect perhaps the credibility of international criminal law?
Well, I think the first proposition is somewhat questionable. I mean, it said a lot of the interpretation is by civil society. I think by interpretation, you probably mean by writings. There are a lot of opinions, there are a lot of writings, a lot of academic articles, and most of this actually are by academics. And of course, many academics also involved in NGOs, and they do advocate various positions. But insofar as the law is concerned, to begin with, international law and international criminal law and international humanitarian law, subsets of international law, is very largely civil law, not common law. So precedent is not a major issue. Courts do not bind each other. There's no doctrine of binding precedent as such. But there is a doctrine of development through practice, through state practice. So there's a lot of state practice that's documented, and state practice leads to the development of the law. But state practice will come in only when the rules of the law are unclear. Now, we talk about development. I agree with you that there's a lot of writing as to how the law should be developed. And not all of these are honest. Some are self-serving. Some are in order to serve various interests. So one has to be rather circumspect. The civil society, or rather the NGO world, I prefer to use the term NGO because that's the term that's found in the United Nations Charter, where the term originated from. The NGO world is a very large world. It's a very large world. It's unregulated, and it's a very noisy world. There are NGOs which are huge organizations, very highly respected, with great history and great reputation, but there are also NGOs which are one person and a computer somewhere in the middle of nowhere. They're also NGOs. So it's a totally diverse world. And I think we want to be careful to attribute developments to NGOs as a whole, unless these have been really accepted by people who are in a position to implement the law. Then you can say, yeah, these are developments. Otherwise, it's a very noisy world. Everybody seems to have their own opinion. Although on most issues, there's a sort of a core opinion. Like, for example, everybody knows that genocide is wrong. But even the meaning of genocide has a lot of shades of gray. I just give you one example. A term which is being used today, which is very popular in Western writings, is cultural genocide, right? In the context of Xinjiang, the genocide there is supposed to be cultural genocide. But cultural genocide was proposed by developing countries during the negotiation of the Genocide Convention, objected to by Western countries, put to a vote, and it was defeated. The idea of having genocide to include cultural genocide was defeated by vote during the negotiation of the Genocide Convention. So then suddenly now you find the term being used by everybody. So obviously there's an agenda here which doesn't quite reflect the law.
Professor, there's another question in the chat. I will read it out for you from Winnie Jagongo from Kenya. It's about the ICC. What body does the checks and balances for the ICC? Is there a loophole that would need to be addressed? Now that you mentioned that the court is accused of being biased, focusing their attention on specific countries.
Well, actually, the ICC has the same mechanism for ensuring its integrity as many other UN bodies, and that is a conference of parties. Conference of parties. There's a conference of parties I think it's every other year. I can't remember exact interval. And the conference of parties will then receive a report, and then they will debate and try to set directions for the ICC. But don't forget, the ICC is a court, and a court is independent. It cannot be controlled by any party. In the same way as the national court cannot be controlled by the executive. The ICC, being international court, cannot be controlled by any state or any group of states, although it does have to make a credible report to the conference of parties. So in other words, you can say that the pressure, the means of having a system of checks and balances for the ICC is through transparency. They must be able to report, and if they do something wrong, then of course statements will be made in the conference of parties where they will not be made to look very good. That's the same for most UN bodies anyway.
Thank you very much. I don't see any other questions for the moment, so I wanted to, before closing, to thank you, Professor Jeffrey Chen, so much on behalf of Nilüfer and myself and the participants for your lecture today. And I really appreciate that you took the time to come and speak to the Academy. Also thought it was fascinating the explanation you gave at the beginning about the Red Cross emblems, including, of course, the newest one, the red crystal. But I think we always hear that the emblem, the initial emblem of the Red Cross is because of the inversion of the Swiss flag, and I had not heard the story about the blood of being the reason, but it makes total sense, of course. So I appreciate you sharing your experience and also telling that to the participants. So with that, I wanted, before we close, because today it's the last guest lecture. We will finish tomorrow this module with Professor Sayapin, but since I won't be able to join tomorrow, I wanted to, on behalf of Dr. Nilüfer and myself and of CIL, to thank all the participants for having endured, again, 10 weeks. Not all of you did 10 weeks, but a lot of you, I've seen you almost every week, for having taken this journey with us. This is the third year we organized the Academy, and we're very proud to always have had an excellent group of participants with very diverse backgrounds in terms of their nationality and their training and their interests, and also especially being very active and interested participants. So I wanted to thank you and also congratulate you for having been participants of the third edition of the Academy. Of course, I want to extend our thanks also to all the guest lecturers and the lectures we've had over the last 10 weeks. We've seen also, we try to match the diversity of the participants also with diversity of lecturers, and I think that again we managed to get to you an excellent lot of lectures and speakers. One last and final word of a special thanks, and I think you will join me in applauding all the support that we've received from CIL, and especially from Jerry, who I see is hiding behind a video screen. And I really want to thank Jerry again for having, with our unique skills, helped us. And that she's really the soul. And I see all the hands going up, clapping. Thank you so much for that. Again, Jerry, thank you so much. Also, Matthew, who you've seen also working with us. Matthew has been also instrumental in managing the Zoom and making sure that everything runs smoothly. We appreciate very much all the help. Last but not the least, a special word of thanks to our very dear assistants, Mohit, who is here with us today, and also Asli. They've been instrumental in liaising with the speakers and helping us also navigate through every week. So a warm thanks from Nilofer and myself, both to Mohit and to Asli, without whom we could not have done this edition of the Academy. So with that, please join me in a round of applause to everybody, to you also, the participants and all the lecturers and all the support staff. So still one more day to go tomorrow, but from my part, I look forward to meeting you somewhere around the world. We know that international law is a small world, and it has happened from my experience that people that I met online in the Academy, after the pandemic, we've been able to meet in person at conferences or courses or at United Nations, you never know. So I do hope that our paths will cross sometime in the future, and all the best for your personal and professional lives. Thank you so much.